All right, we are live. All right, thank you, everyone. We are back a little after 2 p.m. and we have with us Legislative Council, putting more time in on our omnibus emergency response bill. And there were some questions that came up going through the work we did yesterday. So we are here to kind of like dive into those curiosities with legal perspective and analysis. Council.
Good afternoon, Tucker Anderson, Legislative Council, here to bring legal perspective and analysis. So the committee had teed up two primary questions that I'm happy to answer. And if there are any other questions that have come up since yesterday about draft 2.3 of the committee's omnibus emergency management bill, I'm happy to at least attempt to answer them. So the first question that came up was there was some confusion about my testimony related to the disability registries and what some of the legal issues that I was attempting to flag for you. So as initially proposed in the short form in H901, there was a proposal to require rules to be adopted at the state level for evacuation procedures of certain housing units. And then the term was just broadly used high rises. And that system of rules would replace the current practice of using disability registries in order to identify individuals who might need assistance during emergency response or evacuation. The high-rise rules and evacuation plan rules didn't make it into the bill, but the prohibition of the disability registries did. And the issue that I was flagging is that this is the removal of a current practice without a replacement to assist those individuals during a time of evacuation. So I was trying to tee that up as this might be more of an either or situation. Either don't proceed at all with the plan or use both or some other replacement for the disability registry. But there might be unintended consequences, people who need these plans in place if you remove the disability registries but don't replace it with another system.
Rebecca, you have a question?
Thank you. Not a question, but a comment. So the original bill 901 had the high-rise rules and the evacuation rules for a certain number of housing units. And that was very prescriptive, and we heard that that might not always be achievable in an emergency situation in some municipalities. And then we left in, and I think it's inadvertent that we did that, the prohibition, the disallowing, I should say, of the registries. Because we heard today, and I'm not sure if you are aware of the testimony we heard today from the U911 board about the CARE program. And that, in all appearances, is a registry, and it appears to be working well for the 400 individuals who are currently registered. And it also appears that they want to do more outreach to build that registry. So it includes more individuals. They just need to work on their outreach and their advocacy for that. So if we were to remove this section 8 on starting at the bottom of page 13, section 8, the prohibition of certain disability registries, would we then have a compliant piece of legislation that didn't conflict with other pieces of it?
Yes.
Okay. So thank you for that. I'll let you go on to the next question, I guess.
Yeah, that clarified that because I knew that there was some concerns about how those get fit. So
That's why we invited Barb Neal in to talk about that this morning.
yes, and I was asking for that conversation. So thank you very much. Rep Ismail.
So basically, if we're gonna take this out, we really need to find something to replace it with.
We don't have to. It's not a have to.
No, but do, I have a problem, then I don't wanna. what's the word I want? I don't want to discriminate against those who have those disabilities and can't get out of, you know, but then I don't know how you can say that we just don't, I don't want to look like we don't care about the disability rates. That's what I'm saying, by taking it out. So I'm concerned if we take that out, are we just like tossing them aside after listening to the testimony this morning about how many constraints they have already placed on them? So I don't know, or do we put something in there referring to the care
Oh, the care program?
program?
But is it okay to name a program where individuals self-report and encourage that self-reporting to the program?
Yes, but I'd also point out that if you do take section 8 out in its entirety, the care program will continue to exist.
Yeah.
So you're taking something out of the bill, but that section is a prohibition on a current practice for using.
We can't really leave it in because it would prohibit the care program from operating. Reference and all.
Oh, gotcha, okay.
But we could make a reference somewhere to, in the bill, to the care program. And that the fact that it is self-reporting and that first responders and town emergency managers could, I'm
Mhm.
not gonna say shall, but could avail themselves of that registry so that they would know which individuals in their town would need assistance in an emergency. Because that information can legally be released to town emergency managers and first responders
So
and
you're
EMS.
going to
sorry.
the, from the shall to the may, in that one? In like the like legal like sort of sense?
Not sure, it's up to the committee.
Well, just as far as like what you're talking, you're making it like it's the ability to, it's like enabling, it's not,
Yes,
yes.
enabling.
Or pistol.
But should it then be the responsibility of the local EMS and fire departments to have to go after that registry, or should it be the opposite direction? That those with disabilities shall or should or may contact the local to let them know?
I don't think you can force an individual
Right.
person to
No,
do
that's-
anything, so
No.
they are not being obligated to report themselves to a registry or to their local emergency
And but we
folks.
also at the same time don't wanna make it force that the local EMS, whatever, have to look for that registry. So that's, I don't know.
We could ask the local town emergency managers and first responders to look at the registry to ask if there's anybody in their town. They would have to do that on a regular basis though, because people move in and out. So I don't know how that would work to require them. I think it would be helpful for the care program to do more outreach.
Yes,
And they said they're working on that, so maybe we give them a chance to do more work on awareness.
Rep Gotham?
And just, this is more commentary, but I don't know as if there's anything that would stop someone from voluntarily going to their local volunteer fire department, reaching out to their local volunteer fire department saying, if there's an emergency, I'm going to need this kind of help, to let them know. Without it actually being a registry, but them saying, hey, I just moved here. You know, or a family member saying, we just moved here and we have these needs in case of a major emergency or a fire at our place or.
And I would imagine that some folks do that, since there are only 400 people approximately on this registry right now who have self-reported. There might be others who have gone to people in their small towns and said, hey, you know that I have poor eyesight or I have poor hearing or whatever, or I need assistance getting out of my building. There's something happening. So that probably already happens organically.
Something that I've noted,
Kind of figure.
the discussion the committee is having right now is verbatim the description of the program that already exists.
Oh, okay.
Okay.
Thank you, council.
It's a voluntary registry. People can add their details and information to the registry, and it is available to all first responders who might be called in for a number of emergency responses at that individual's address. And it allows the first responder to access whatever special accommodations or needs information has been added to the registry for that registrant. And it is
Thank you.
And I do want to be conscious
Mindful of his time.
conscious of council's time. We are at 17 minutes with council.
Oh.
Please
Okay.
proceed, sir.
all right. The second big question, second and last, was are there existing statutes that protect law enforcement officers from obstructive conduct or conduct that impedes the exercise of their legal duties? There are, in fact, some existing protections in place. So I'll cover them at the high level overview, flag the standards that are used and the criminal penalties that are associated with the conduct. I am aware of 5 Title 13 statutes that relate to this. So the first is assault of a protected professional. And that is a person convicted of a simple or aggravated assault against a protected professional while the protected professional is performing a lawful duty or with the intent to prevent that professional from performing a lawful duty. The penalties are imprisonment for not more than 1 year. And then for second or subsequent offenses, imprisonment of not more than 10 years. Within the definition of protected professional, you have law enforcement officers, firefighters, healthcare workers. So that covers the first responders that are covered under the proposal in your bill. That is in 13 VSA section 1028. 13 VSA 1031, interference with access to emergency services. A person who during or after the commission of a crime, so there is a specific proviso there. So another crime is being either committed or has just been committed. Willfully, there's your standard, prevents or attempts to prevent a person from seeking or receiving emergency medical assistance, emergency assistance from a third party, or emergency assistance from a law enforcement officer shall be imprisoned not more than 1 year or fined not more than $5,000 or both. 13 VSA section 1702, criminal threatening. A person shall not by words or conduct knowingly, there's the standard, threaten another person or a group of persons, and as a result of the threat, place the person in reasonable apprehension of death, serious bodily injury, or sexual assault. Person who violates that shall be imprisoned not more than 1 year or fined not more than $1,000 or both. And there is the express application of this to public servants, including law enforcement officers. (13) VSA section 3001, impeding public officers. A person who hinders an executive, judicial, law enforcement, civil, or military officer, so brings in the National Guard there as well, acting under the authority of the state or who removes a weapon from the person of a law enforcement officer, shall be imprisoned not more than 3 years or fined not more than $500 or both. And then finally, hindering an arrest. A person who intentionally hinders an arrest of another, which is being effected or attempted by a law enforcement officer when it would reasonably appear that the latter is a law enforcement officer, shall, for the first offense, be imprisoned not more than 1 year or fined not more than $500 or both. And for second and subsequent offenses, imprisonment of 2 years and a fine of $1,000. So moving through each of those, they don't universally apply to first responders in each instance. You'll note that for each one of those, law enforcement officers are bundled within the defined officers that are covered by the statute. The fire personnel and EMS are not included universally in all of these. And there's variation in the type of duty that's being carried out, and also in the standard that is applied to the individual's conduct that is being deemed criminal by the statute. And I'm happy to kind of maybe flag the Venn diagram of conduct that's covered here so that you understand what exists in current law versus what is being proposed in H 697 and the version of H 697 that is currently contained within draft 2.3.
Okay. That's how, maybe, yeah, to
Yeah.
put all those pieces together on the overlay. Yeah. So, yes, we're up orders.
It's possible in theory to add EMS and fire rescue people to those other, to already existing.
To some extent, but again, because some of these statutes apply to specific duties such as arrest, it wouldn't apply to some of these officers because they don't perform arrests. But yes, in theory, it is possible to include first responders broadly in some of these. Some, not all.
Right, I know.
Question for you, would that be something that you would be interested in trying to do with this bill? And for Tucker, is this something we could do with this bill?
So something that I'll note about each of these statutes as well is that the type of conduct doesn't extend to the scope of what you were considering in draft 2.3, largely because the ones that are universally applicable are typically dealing with criminal threats or assault and don't cover conduct that merely impedes the exercise of the duty, which might be, for example, providing CPR or whatever the situation may be that an EMS professional is providing. And some of them are contingent on the commission of other crimes. So, right, there was that one that I flagged that the proviso is that this crime in 13 VSA 1031, interference with access to emergency services, only applies if the person is actively committing another crime or has just committed a crime, right? It doesn't protect the professional or the person who's seeking medical assistance if no other crime has been committed. So maybe it would be helpful if I did map this out for the committee so that you could take a look at what already exists and understand the officers, the conduct, and scope.
Okay. Rep Nugent, we are at 4 minutes with council.
All right. I was just curious, just to confirm that you said, so it's not illegal currently to impede someone who's doing those other types of services for somebody like giving CPR.
As long as you don't hit some of these other criminal thresholds that exist, I was not able to find it in the time I was able to commit to the research. I did reach out to some others and confirm that I had captured the limited universe that exists.
My other question might be more of like a research question, but I was just aware of similar issues with, airline staff, for example. Just a lot of aggression and I think assaults happening. And so I think Congress passed a law recently or last year that gave airline staff more authority to try to deal with similar issues. So I was wondering if we had looked at that or if there's anything we could draw from that would be helpful.
I can certainly take a look at it. I remember you bringing that up yesterday while I was listening on YouTube, I think.
To answer Rep. Hango's question, my concern is not that I feel like it should be okay to impede people from their rescue activities or that it's okay to assault people. I wish I had known that Tucker was just gonna come do all this because I wrote it all down this afternoon. I was looking through them all myself. I am, and it's the preventing people from limiting the distance that they can get is really the sticking point for me. It's not that I think it should be okay to jump on someone's back when they're trying to give someone CPR. And I think that if there isn't a law that specifically prevents that, then that is a preferred avenue for me, even if it's not in this bill necessarily. But I would rather see this come out of this bill and then, we commit to working on it in, upcoming years to make sure, or talk to someone in judiciary and see if that maybe that's a more appropriate place for it to be worked on. I am so, as you know, deeply bothered by limiting people's access in any way, 25 feet or 0 feet. Even if people are saying, and I heard people yesterday saying, well, it's not meant to target journalists, but I think we often see that when even if a law isn't meant to do something, it can allow other things to happen that are undesirable. And for me, preventing journalists from doing their work is just a full stop. So if there were other avenues to pursue to make it possible to make it against the law, like some of the things folks mentioned yesterday is unfortunate, but it's, I believe, already illegal to hold a gun to someone's head. So some of those things, it seems like if it's already against the law, then you're not going to be like, I know it's against the law to hold a gun to someone's head. Oh, but wait, I'm also not supposed to be within 25 feet of this. So wait, I'm not going to go do that. Like, I don't think that's really going to be, if it's already an illegal activity, I don't think adding another law to it is going to make it not happen. So I would rather pursue it from literally any other avenue I'm open to. But the adding that distance there and preventing people from doing their jobs as journalists and protecting our First Amendment is just like a full no-go.
Okay, thank you. So if
Yeah.
we removed that 25-foot clause and we defined what behavior would trigger a violation, because we heard from just about everybody yesterday that journalists and the media are not the problem.
Yes.
So the problem, and I think Commissioner Morrison said it very clearly, the problem is when somebody does something that impedes. So if we can define what people are doing to impede or obstruct and go from there and remove the 25-foot barrier.
I would rather remove the entire bill.
I'm offering a compromise.
Yes.
So if you can think about that.
Yeah.
Tucker needs to leave.
Yeah.
So we'll just let you know how that goes.
I had a hand from Cotton. You have 38 seconds, sir.
Okay, so quickly. Sort of like what Rep. Hango said, if it was stated in B, it's unlawful for an individual to intentionally engage in any of the following conduct during a public safety emergency. And that removes that distance. And I know there'll need to be more language, but it removes the distance. But also in this, where it says shall be imprisoned, we could change that to maybe, and that gives the prosecutor the options. And it's also with the 60 days of no more than 60 days is a lesser charge, a lesser time than all the other statutes we heard that go up a year or two.
Okay. And that's time with council. You're released, sir.
Thank you, Tucker.
Thank you all.
All right. So
I have one comment.
is that Tucker or?
Nope.
Oh, no, that is a host Tucker. Okay, yes.
Actually, I have two things.
Okay.
So one of the things I wanted to correct something that I said yesterday when we were talking to, or maybe, no, sorry, it was this morning, when we were talking to Barb Neal, and I said rounded figures or round numbers for the budget process. That is not coming from downstairs from House Appropriations. It's more like I should have said ballpark numbers rather than rounding, because downstairs they want specifics. But for this particular case, because the money was previously appropriated in a previous biennium, they already have the money. So it's not something that House Appropriations has to give them above and beyond what they're already giving folks right now in the current budget they're working on. So hopefully that clears that up. And I had a second thing. I had asked Tucker the question about it had come up yesterday, I think, in his testimony to us about the unincorporated gores and municipalities, town fire wardens. That's probably something that will have to get ironed out in the Senate, except he did not have time to address that today. So I will ask him again and we'll go from there, because I think we'll have Tucker back in with us tomorrow.
Yes.
So that's all I have.
That is part of our agenda planning process once we go off. So for those of you who have bills moving, just we got some updates on regional planning governance and OPR were voted out. So we know those things are in the pipeline. Representative Boyden, you have a bill on the floor today. We are going to do agenda planning once we sign off now to start dialing in tomorrow. And then I had a plus to have my phone in my hand in a private place to have a conversation at 3:15 before I have a speaker's conversation at, 3:00 phone call, 3:15 speaker to get to the floor by 3:30. Right, pissed off.
In regards to trying to reach a compromise regarding section B of this bill that we just listened to, is there any way that we could somehow word it that news reporters or whatever would not be part of that?
Yeah, yes, Rabbi Ango.
It could turn into an issue, because we would be carving out for a very specific group of individuals, and we
Okay.
would have to very specifically define them. We've investigated that possibility
Okay.
already, and council advises that that is kind of a slippery way to go.
Okay,
And I think there was a previous bill where we tried to like kind of look at a definition within that. And I think that was difficult, if I remember correctly. But
We defined it in the, when the last session, when we were doing the, what was it, 244, the
Yes.
journalism one. But that was, we were defining what local news was. We
Correct.
weren't defining what a journalist was. We worked on it a little.
And I
It's
had
not
that in my
applicable.
ear, but then it was like the biennium's passed or
Yes.
coming up. It
Yeah.
might have been before you were here and it was sticky. I just remember it being a conversation at one point. It was difficult to do, especially now with the prevalence of digital media. So like a credentialed journalist isn't exactly as like a narrowed scope as it used to be back in the pre-digital days. But with that, I am going to take us offline now so we can do agenda planning. Yes.
I just wanted to tell everybody one thing first. We got an email at 8:41 that animal welfare is going to be on the floor on Friday.
Okay. Yes, I see. Stuff's moving.
It came out of Ways and Means unanimously. So
Nice. It's stuff is moving.
good work, you guys.
The boat is in the right direction right now. Well done.
Okay.
All right, take us off. We're gonna do a little